say that more than once. Please proceed.
I'm terribly sorry about that, Your Honor. May it please the court, my name is Nick Straley, and I'm here in my offices with my colleagues Janet Chung and Nicholas Allen, and we represent the petitioners in this matter. Your Honors, COVID-19 is so dangerous and so contagious that it's actually illegal for us to be in the same room this morning. But nonetheless, my clients sleep in the same room with 2 or 3 or 25 other people. And when they wake up, they're crammed into day rooms, they're crammed into mess halls, they share the same bathrooms, the same sinks, they share the same tablets, the same computers, the same telephones. And Your Honors, overcrowding is always unpleasant. Sometimes it's unconstitutional, but in this case, it can be deadly. And that's why we're here this morning. We're asking for an extraordinary remedy to fit an extraordinary moment.
That is Cheyenne Colvin et al. Versus Governor in April 23rd, 2020. And the court is conducting oral argument this morning via Zoom. We're hearing one case this morning. That is Cheyenne Colvin et al. Versus Governor Inslee et al. I went to welcome counsel in April 23rd, 2020. April 23rd, 2020. And the court is conducting oral argument this morning via Zoom. We're hearing one case this morning. That is Cheyenne Colvin et al. Versus Governor Inslee et al. I went to welcome counsel, and thank you for appearing by Zoom. And for the petitioner, we have Mr. Nicholas Straley, who will open for 22 minutes, having reserved 8 minutes for rebuttal. And for the respondent, we have John Sampson. So, Mr. Straley, if you would like to proceed. Mr. Straley, you're muted currently. Just ask you to start your volume. That'll be, I'm sure we'll have to say that more than once. Please proceed.
I'm terribly sorry about that, Your Honor. May it please the court, my name is Nick Straley, and I'm here in my offices with my colleagues Janet Chung and Nicholas Allen, and we represent the petitioners in this matter. Your Honors, COVID-19 is so dangerous and so contagious that it's actually illegal for us to be in the same room this morning. But nonetheless, my clients sleep in the same room with 2 or 3 or 25 other people. And when they wake up, they're crammed into day rooms, they're crammed into mess halls, they share the same bathrooms, the same sinks, they share the same tablets, the same computers, the same telephones. And Your Honors, overcrowding is always unpleasant. Sometimes it's unconstitutional, but in this case, it can be deadly. And that's why we're here this morning. We're asking for an extraordinary remedy to fit an extraordinary moment. And why are we here? Well, because the state has violated its duties to our clients, and there is a remedy that this court can and should provide to the petitioners. Where does that duty arise? It arises from Article 1, Section 14 of Washington's Constitution, the Cruel Punishment Clause. And what does that duty require the state to do? That duty requires the state to protect our clients, the petitioners, and everyone within the Department of Corrections from a substantial risk of serious harm. That's the standard set out in the Farmer case and the Helen case. And what does that mean? Well, in the context of an infectious agent, all of the case law is clear. That in failure to protect from
square with pictures of people one on top of another at Monroe.
Your Honor, those photographs, first of all, they were taken almost 2 weeks ago, before any
of discretion to do other
allegations. I see that I'm out of time, and I'd like to resume unless there are any further questions.
All right, thank you, Mr. Straley. I'll let you know when you come back for rebuttal how much time is remaining.
Appreciate it.
Turn now to Mr. Sampson, arguing on behalf of Governor Inslee and Secretary Sinclair. Mr. Sampson.
Thank you, Chief Justice, and may it please the court. I am John Sampson, Assistant Attorney General for the respondents, Governor Inslee and Secretary Sinclair. For months now, the respondents have exercised their discretionary authority to protect all Washingtonians, both those incarcerated and those in the community. They have made difficult decisions on how best to protect the incarcerated population, how best to protect public safety, how best to avoid future harm to victims, and how best to protect those individuals who are released when they go to the community.
Mr. Sampson, can I ask you exactly where we're at with that now? I understand that as to one of your clients, Governor Inslee, the proclamation that was issued suspended a lot of laws and gave him and the secretary a lot of discretion to do other things. What has the secretary done? Have those 1,100 people that you've identified actually been released, or is that an aspirational number?
No, Your Honor, it's not aspirational. They have, many of them have been released or in the process of being released. The governor's direction gave 7 days from the date of the order, or as soon as reasonably thereafter as can be accomplished. And it's my understanding that as of this coming weekend, the prison population will actually drop down below 16,000. Currently, my understanding is it currently rests just above 16,000, which is a reduction from the close to 18,000 that had, I believe it was 17,700 before this action started.
Is that enough?
Your Honor, it's the respondent's position that it is currently enough under the current situation, under the current circumstances, based on CDC guidelines, based on the chief medical officer's evaluation, based on the infectious disease physician's evaluation. That reduction should be enough when coupled with the reduction of violator population. The department, before this action started, made a discretionary decision not to arrest low-level violations, not to arrest for those.
So those have certainly made a difference, but we've all seen the ombuds report and the photographs there. How does what you're saying square with the pictures of people one on top of another at Monroe?
Your Honor, those may include Mr. Duncan in one of the early
facility. It's silent on that. And in fact, the women's facility is well known to be overcrowded. That's why they have people at Yakima. In fact, they haven't demonstrated they are actually quarantining any women that come in off the street. Third, it's interesting that the only evidence that he's discussing is from our experts. The only evidence from a medical expert or a scientist comes from the petitioners. The defendants, the respondents, haven't presented you with anything scientifically valid to support what they are talking about. That's important. 2, remedies. Mandamus and PRP, or habeas corpus, are equitable remedies. They can be used to fit a particular circumstance. So, if it requires a mandamus that a monitor to be appointed, you have that authority under the Constitution. And remember, you all can waive any particular rule of appellate procedure that may be limited. We don't.
Can I ask you about that, Mr. Sturley? Because, I mean, the mandamus, both the habeas authority and the writ mandamus authority come out of Article 4, Section 4, insofar as this court. And I'm still concerned that there's not a precise thing that you would have us mandate. It would be, exercise your full authority, comply with the Constitution. It seems a very general obligation that they have plenty of discretion to figure out how to exercise, and that just doesn't seem like so it's not a procedural rule I'm concerned about, it's that constitutional prerogative of when the judiciary gets to interfere with the exercise of discretion by another branch, especially in an emergency.
And I'm absolutely right, Your Honor, that is a concern. But here we have demonstrated a very precise duty. The duty is to protect our clients from COVID-19. And all of the scientific evidence before the court indicates there have to.
Can I ask you again about the special master? Because why would that person, or a member of this court, or the entire court, be in any better position to determine what's best practice?
I would say that they would be, because they would have evidence that is currently before the court on the precise question. But what is before the court is that they are currently operating an unconstitutional system. And that's the most important thing, because as this court determined in McCleary, you have an obligation to step in to rectify an unconstitutional circumstance. And that is the undisputed evidence in the record. Okay?
But do you agree that in McCleary, the court emphasized that what constitutes a basic education and how best to provide it is entirely within the legislature's prerogative? So why is it not entirely within the executive's prerogative to determine how best to address COVID-19 outbreak in prisons?
Because there's no dispute that the fact that releases are essential. Because if people are not released, they are operating in unconstitutional circumstance. They have alleged that they have now released people, and they have alleged that that's sufficient. They haven't proven that, and it's their burden to prove that, because they are operating in an unconstitutional prison system, and all of the evidence is to the contrary, Your Honors. All of the independent evidence is to the contrary. That's the point. There is no real material issue of fact here. The evidence before the court documents this is unconstitutional circumstance.
We have a question about whether social distancing actually works.
Well, Your Honor, I believe that social distancing is the only tool that has truly been identified to keep as many people safe as possible. That's why we are all in quarantine, as I understand.
No, we're not all in quarantine. I live with my family. We're not all in quarantine. We live sole. I don't know of anyone who is living completely alone. Maybe there are people, but I don't know who they are. We all interact at various points, and we know that even 6 foot distancing, there are COVID particles in the air. So I guess what I'm asking you is if it were a sure thing, and if we're not doing it, then you might be in a different position. I just wonder, where is the evidence that it is a sure thing, that if we social distance, we are ensured of protecting each other, or in your case, your clients?
Your Honor, I agree it's not a sure thing, but that's the issue with this disease. And what we're doing is operating on best available information. And the best available information from the CDC and every scientific organization is that social distancing is truly the only thing that can be done to prevent people from getting this illness. And while it's true that people are meeting together, the difference between what we can all do out here and what people in
3rd, 2020. And the court is conducting oral argument this morning via Zoom. We're hearing one case this morning. That is Cheyenne Colvin et al. Versus Governor Inslee et al. I want to welcome counsel and thank you for appearing.
He's bringing it up right now. What's the phone?
509-488-9619.
So, $199.
Thank you.